Good day, Crime Talk aficionado. It is the end of the week, and we still have another great show for you. First, witnesses were subpoenaed in Pennsylvania for the Bryan Kohberger trial. Hank Brennan gives a masterclass on cross-examination of the ARCA witness. A Florida sheriff gambled and lost. A man describing himself looking like SpongeBob gets arrested, and guess for what? We have this day in legal history, our legal quote of the day, dumb criminal of the day. Let's talk about it. Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't, like if you do, leave me a comment below, hit that bell for notifications, and yes, you can go check us out on any of your favorite podcasting apps. Now, before we get to the docket, let me remind you to go to crimetalksearch.com and sign up for that background subscription service today. When you do, you'll be able to do a background search on anyone here in the United States. The report is literally prepared while you wait, and it's going to have background information about the person you're searching for. Some of the most important stuff you're going to be able to find is what cell phones numbers are associated with this person. How about their social media presence, email addresses? Do they have a legal history? Do they have judgments, liens, criminal history? And yes, do they have to register as a sex offender? All those things you want to know that maybe somebody may not necessarily tell you when they're trying to get to know you. You want to go check them out. So go to crimetalksearch.com. You're going to be happy that you did. All right, ladies and gentlemen, it is Friday, June 6, 2025. And I don't know about you, but it has been a long week and ready for the start of the weekend. Why? So I can come in and get some more work done this weekend because it's just been busy. Anyway, let's go ahead and begin. Let's open the record. First case on the docket, once again, Bryan Kohberger. So witnesses have been subpoenaed in Pennsylvania for the Bryan Kohberger trial. And this is a total pain in the butt. Let me tell you this, ladies and gentlemen, because think about it. If you have a witness who is out of state, and let's say, for example, they're in Pennsylvania and you're in Idaho, how do you do this, right? The court in Idaho has no jurisdiction over the person in Pennsylvania. So unless they're going to agree to waive service of process and come voluntarily, maybe sign a waiver of service, what do you have to do? Well, you have to get your subpoena, usually issued by the court directly in the state. So, for example, Idaho. Then you find a local attorney or prosecutor in that particular jurisdiction that will get it set on the court docket, serve the individual with a date to come to court, and thereby the court will then order the individual to get on an airplane and go to the state of Idaho. Pain in the butt. Normally, you hope out-of-state witnesses will come voluntarily. But if you don't go through this process, guess what? If they don't get on the plane, you have no remedy as far as contempt. So there's nothing you can do. You're just like, oh, we didn't get them. And then when your client loses, they're going to come back and say you didn't get this witness and you're ineffective, and that witness would have changed everything, and therefore you were ineffective. Pain in the butt. It's a procedure you got to do. There's a kind of interstate compact among all the states. It's just a pain, but they're doing it. So, in preparation for the capital murder trial of Bryan Kohberger, scheduled to begin on August 11th, a Pennsylvania court has issued subpoenas to 5 individuals connected to Bryan Kohberger's past. These witnesses include a former professor and a boxing gym employee, and they were all ordered to attend a hearing on June 30th, 2025, to justify why they should not testify in the case concerning the November 13th, 2022 murders of 4 University of Idaho students. Obviously, that includes Kaylee Gonzalez, Madison Mogan, Zana Kernodle, and Ethan Chapin. Now, the summoned individuals include Michelle Bolger, a DeSalle University professor who taught Bryan Kohberger during his criminal justice master's program. And Bolger previously expressed shock, describing Kohberger as a, quote, brilliant student, end quote, and stating, quote, I don't believe it, but I get it, end quote, upon learning of the accusations. Then we have Ann Parman, an advisor at DeSalle University, Jesse Harris, an employee at the boxing gym where Kohberger trained daily, as noted in a 2015 job application. We have Ralph Vecchio, Vecchio, and Maggie Sanders. It's unclear what role they played in Bryan Kohberger's life previously or why they would be needed at the trial. Now, most of these are probably mitigation witnesses for sentencing, but, well, I'm telling you what we know so far. Like I said, the purpose of the last two's testimony is unclear, and it's also unclear whether it's for the prosecution or the defense. It's unclear from the filings there in Pennsylvania. Now, for those who don't know, obviously Bryan Kohberger faces charges for the brutal stabbing of the 4 Idaho students at their Moscow, Idaho home. Obviously, evidence linking Bryan Kohberger to the crime includes DNA on a K-bar knife sheath button. Yes, the little button on the little knife sheath. And that was found under the scene it was found at the scene under one of the victims, specifically Madison Mogan. There's obviously cell phone records placing Mr. Kohberger near the victim's home multiple times before the murder, as well as surveillance footage of a vehicle matching his car fleeing the area. Now, obviously, he's been arrested as of December 30th of 2022. That took place at his Pennsylvania home in Pennsylvania. And obviously, Kohberger faces the death penalty if he is ultimately convicted. Now, Kohberger's defense team recently filed a sealed amended mitigation witness list and introduced a motion to present alternate suspect evidence at trial. In that April 2025 hearing, Ann Taylor, one of his lead attorneys, revealed a lead on another suspect discovered among police tips. The defense also suggested Kohberger's DNA may have been planted at the crime scene, by the real killer, and proposed that 2 perpetrators using the weapons committed the crime. And then on May 23rd of 2025, the defense submitted evidence to support their claims, with the prosecution required to respond by June 6th, which is today. So hopefully we'll get an order on that very shortly. A hearing later in June will also determine if the alternate suspect theory can be presented. Now, we did a video I guess it was last week or so, about what the defense has to show in the alternate suspect. And basically you have to show is that really the police should have arrested this other person because they were basically at the scene. They did it, and you should set my client free, or unless, of course, they were acting in concert, i.e. a conspiracy or complicity or complicitors. Anyway, Bryan Kohberger hasn't been released, and as far as we know, no one else has been arrested. The judge didn't say, oh my gosh, look at this alternate suspect information. I will sign a warrant for this particular individual. So, color me skeptical as to whether this will come in. It's very difficult for alternate suspect information to come in. And even if you get it in, doesn't necessarily mean that the alternate suspect did it, or a jury will believe that at all. Obviously, the defense plan strategy is to significantly impact the trial if the alternate suspects comes in. Because, hey, if you can convince just one juror of a reasonable alternate suspect, well, it could lead to possibly a hung jury. Who knows? Maybe a complete acquittal. We'll obviously have to wait and see. Now, the defense has also requested a continuance of the delay, citing the recent Dateline episode that disclosed what the defense describes as sensitive details, including Kohberger's phone records, online searches, and unseen surveillance footage. The judge overseeing the case issued a stern order suggesting a gag order violation by someone close to the case, and he initiated an investigation to identify the leak, and he ordered both sides to preserve records and to provide names of all of the individuals with access to the information that was released. This development obviously raised concern about the seating of an impartial jury, and let's just say the judge was not amused. So as the trial approaches, they're making arrangements for witnesses to appear at trial. We'll see how the alternate suspect goes. There's a hearing on June 30th that will clarify any witness roles, while the court will also rule on the alternate suspect evidence, which could obviously shape the trial's outcome. Obviously, the CrimeTalk aficionados will be watching along with the nation, and the proceedings will test the judicial system's ability to balance evidence, media influence, and justice in a case such as this. Now, in recent court filings as well, because sometimes they're a couple days behind, the court granted access to sealed records dated March 5th, 2025. And of course, that's all sealed. Interesting, because somebody took the time to get access to the sealed records and the court granted it. Very interesting. I'd be curious to know who was involved in that. What did they get? And if it's able to be unsealed, why shouldn't the rest of us get to see it as well? Next on the docket, day 28 in the Karen Read case. And listen, I'm not going to try to convince people. You all believe what you want to believe. We'll find out what the jury believes. But I'm telling you, today, the cross-examination by Hank Brennan was a masterclass in cross-examination. Don't have to believe me. I suggest go watch it today. You can watch today's trial on CrimeTalk. It was interesting, but let's get to a recap of today's testimony. All right. So Dr. Wolf testified. He's the director of accident reconstruction at ARCA, and he took the stand. Mr. Jackson clarifies that Dr. Wolf was not initially hired by the defense, noting their involvement began with an outside agency. It never came in that it was the Department of Justice that they were hired by. And the prosecution objects as to how Jackson introduces this, leading to a sidebar. And guess what? All they can say is that it was an outside agency that hired him, not the Department of Justice. Anyway, as the testimony began, Mr. Wolf testified about his analysis of Karen Read's Lexus SUV, stating that the tailgate damages was generally consistent with being struck by a drinking glass, not the hitting of John O'Keefe or a pedestrian. He confirms producing a report and testifying at the prior proceeding last year. As things go on, Mr. Wolf presents a PowerPoint addressing the conclusions of the prosecution expert, Dr. Judson Welcher. He criticizes Welcher's tests as very basic and leaving key questions unanswered, particularly regarding taillight damage and Mr. O'Keefe's injuries. Jurors apparently were noted to be quite attentive, taking notes during that process. As it continued, Dr. Wolf provides a physics lesson displaying images of Read's SUV with a broken taillight and a model of a Lexus taillight, setting up their victim impact analysis. Jackson attempts to question Mr. Wolf about Welcher's use of the scientific method. The prosecution objects repeatedly, and after Jackson fails to rephrase, they called another sidebar. Anyway, Wolf explains his analysis tested Welcher's hypothesis that O'Keefe's arm contacted the taillight, aiming to determine potential injuries from such an impact. The prosecution sustains multiple objections, forcing Jackson to rephrase many of the questions. Then, Wolf describes tests using a Lexus SUV and a crash test dummy to evaluate the damage. He notes that lab tests were conducted to assess vehicle-pedestrian interactions. Wolf then presents a video from a PowerPoint showing ARCA's testing, including a taillight device striking a crash test dummy to stimulate a vehicle impact. Well, then that was the morning recess. Jackson continues, addresses ARCA's compensation after the break, a prior point of contention, and Wolf confirms that ARCA was paid $20,000 after the trial in 2024 for travel time and testimony time, but not for the initial report, as he was compensated some $50,000 from that outside agency, the Department of Justice. Jurors appeared engaged, apparently, by courtroom observers as Wolf discusses tests at various speeds, specifically 15 miles an hour, 17 miles an hour, 24 and 29 miles an hour, showing video comparing test taillights to Read's. Wolf testifies the damage was inconsistent with Read's taillight at all speeds. At 29 miles an hour, additional damage, for example, shattered rear window, liftgate was damaged, that all occurred, unlike Read's vehicle. He notes no taillight pieces punctured or frayed the dummy's hoodie sleeve, unlike Mr. O'Keefe's clothing. Then Mr. Wolf concludes that the test results showed damage to the dummy's sweatshirt as clearly road rash, inconsistent with O'Keefe's sweatshirt. Jackson finished his direct examination, and we moved to cross-examination after lunch. Now, Mr. Brennan begins cross-examination questioning Wolf's credentials and certification testing. Mr. Brennan established ARCA works for insurance companies and that Wolf initially was hired by another agency, not the defense or the prosecution. Brennan asks why Wolf deleted text communications with the defense, and Wolf explains he routinely deletes logistical conversations with attorneys and clients as they are not typically retained. Brennan questions Wolf's use of Signal, an encrypted app, noting the defense requested its use. Wolf confirms Signal does not retain records by default, and he agreed to use that. Brennan then probes Wolf's provision of a question list and answer notes to the defense, calling it a script. Wolf denies this, describing it as an outline to clarify his work for the jury. He emphasizes that his responses are only about not physically inspecting the vehicle, was to ensure jurors understood it and did not affect his analysis, regardless of who asked the questions. Now, Wolf maintains his notes aimed to explain, not mislead. Then Wolf's knowledge of his colleague, Dr. Andrew Rentschler's report, focusing on sources, citing about crash test dummies, suitability for addressing clothing tears or skin abrasions. And Wolf admits that he read his colleague's report, but didn't really review every source, relying on his colleague. It's an indication that the hybrid 3 arm was appropriate for analyzing the arm injuries. Now, the defense objects multiple times, leading for another sidebar, and then Brennan was allowed to continue. Mr. Brennan focuses on the weight difference between the crash test dummy, 9.38 pounds, and O'Keefe's arm, 11.86 pounds, a 26.3% difference. He asks if it impacts test results. Wolf testifies that with a 6,000-pound vehicle, the weight difference would not significantly affect damage in field tests. Well, Brennan then presses on testing variations versus real-life conditions, asking if a harnessed dummy affects movement compared to an unrestrained pedestrian. Wolf acknowledges pedestrians are typically unrestrained, and that could impact the analysis. Brennan questioned how the dummy mass, vehicle speed, and other factors alter results, concluding if weight matters. Wolf responds, it can, and if it's significant, yes. Then Jackson resumes redirect, playing a video from the 24-mile-an-hour test. He asks about damage to the crash test dummy's sweatshirt, which Wolf confirmed showed clearly road rash, inconsistent with O'Keefe's sweatshirt. Well, Jackson establishes ARCA was not hired by an insurance company initially, despite frequent works with them, and clearly their other agency engagement. And Wolf confirms no one weighed O'Keefe's arm, and he is unaware of the source of Brennan's 11.86-pound figure. Well, the court adjourns early due to a juror having a commitment, with Mr. Jackson noting more questions about Wolf testimony that'll go over the weekend as well. Now, let me just tell you this, ladies and gentlemen. Now, Dr. Wolf seems like a smart guy. If you're an insurance defense firm, you're going to want to hire this guy, right? He knows how the game is played, and he kind of comes with his analysis. Now, interestingly enough, the first trial, they testified about shooting a glass at the rear tail light, because that was somebody's theory that's possibly how the glass got broken and how the rear tail light got broken. Totally different this time. Then they go and they recreate prosecution's experts testing, and by the end of it, he's basically conceding that this could happen. Initially, he said, well, there couldn't have been a strike, it's not possible, etc. But by the end of it, at least from my perception, he's agreeing that it could happen. They recreated it. They talked about the mass. They talked about the injuries. Dr. Wolf, smart guy, not saying he isn't, but I'm telling you, like I said, this was a masterclass in cross-examination. Brennan got out more for him, for the prosecution, than the defense got for the defense. They really did. By the end of it, he basically conceded that, yes, this is consistent with a car hitting this particular individual, and that it could have been as a result of this collision, on top of the fact that his methodology was basically flawed. Now, I don't know if Brennan came up with this himself or if he had lots of help from his own expert witnesses. I'm assuming he did. But I'm telling you, if I was teaching a class to young lawyers, I would say, watch this direct, watch this cross-examination. Wolf fought him, and Brennan kept going back and back and back. And at the end of the day, so weight does matter. And he ultimately had to concede. He didn't want to admit that the weight variation in the testing of the with the arm and the dummies and things of that nature, that weight matters. And like I said, I don't know what the jury's going to do with it. Really don't. But I'm telling you, watching him do his work, watching Mr. Brennan do his work, literally, people should take note. That was an incredible cross-examination, and he got everything he wanted from the good doctor, short of him saying, fine, yes, Karen Reed hit John O'Keefe in her car. That wasn't going to happen, but that's about as close as he got through the day. I know some people say he was terrible. The defense nailed it. They got everything right. Reasonable doubt, reasonable doubt, reasonable doubt. And it may be. But at the end of the day, there's only 12 people that their opinions matter, and we'll have to wait and see how the jury decides this particular case. All right, next on the docket, a sheriff gambles and loses. The Osceola County Sheriff arrested in a $21.6 million illegal gambling scandal. So the Osceola County Sheriff, Marcos Lopez, was arrested Wednesday morning by Homeland Security investigating agents supported by the Florida Department of Law Enforcement on charges of orchestrating a sprawling illegal gambling operation that prosecutors say generated $21.6 million. The arrest marks a dramatic fall for the county's first Hispanic sheriff, who faces two first-degree felony counts, racketeering, conspiracy to commit racketeering as well. Now, Lopez, who joined the Osceola County Sheriff's Office back in 2003 while serving in the Naval Reserves, was elected sheriff back in 2021 and reelected once again in 2024. His tenure, however, has been marred by controversy. In 2022, Lopez and 4 deputies were named in a civil rights lawsuit filed by Romaniki and Baldwin LLC and the Pendus law firm, stemming from an incident where deputies tackled a man at a gas station, causing burns over 75% of his body. Now, the investigation into Lopez's alleged criminal activities began in 2023 when it was uncovered that authorities described as a sophisticated gambling network involving lotteries and slot machines across Lake and Osceola counties. Prosecutors allege Lopez played a multifaceted role in protecting and expanding the operation, personally benefiting through campaign contributions and secret payments. Now, the Florida Attorney General, James Uthmeyer, announced that charges in a statement calling it a solemn day for Florida and our law enforcement community. He emphasized the public servants should never exploit the public's trust for personal gain. And they released video footage that shows agents approaching Lopez, who asked, "What is this about?" before being handcuffed and led away. Now, following the arrest, Governor Ron DeSantis issued an executive order suspending Lopez from office and appointing Florida Highway Patrol Central Region Chief Christopher Blackman, a 35-year veteran, as the interim sheriff. Now, Lopez was booked into the Lake County Jail without a bond. He has an arraignment on June 30th, and if convicted, he faces multiple decades in prison. Needless to say, sharp criticism from law enforcement and community leaders, and Polk County Sheriff Grady Judge condemned Lopez, stating he has embarrassed himself, his family, the great men and women who work at the Osceola County Sheriff's Office. Indeed. Anyway, another commissioner down there said, as law enforcement, we are held to higher standards of integrity and character. And this case reveals that Lopez violated the trust and integrity expected of him. An attorney, a longtime critic of the sheriff, remarked, "It's terrible when any public official is accused of crime, but I can't state that I'm surprised." Anyway, attorneys from the 2022 civil lawsuit issued a joint statement asserting that Lopez arrest reflects a deeply rooted culture of unlawful behavior from the very top of the Osceola County Sheriff's Department. Needless to say, community leaders are in dismay. It's unsettling, is what they described, and it's extremely serious and disturbing, as you can imagine, all the comments, and they, of course, don't condone it, and they pledge their support to the interim sheriff and going to unravel the full scope of the gambling network. I don't know, ladies and gentlemen, that's bold, isn't it? I mean, man, I don't even know what to say. I just don't even know what to say. I've represented several police officers that have gotten in trouble over the years. And it's always about the money, I guess you could say, right? Always about the money. And this clearly is the case as well, allegedly. We'll give him the presumption of innocence that he's entitled to. But, you know, the reality of it is that's disturbing. You know, if you are a public servant, I don't care what kind of public servant you are, you know you're going into it. You're not going to make millions of dollars. You're doing it for the public good. And you are held to a higher standard. And if you can't do that, then you need to leave. And if you do cross that line, guess what? You need to be held accountable more so than just the everyday individual. I had a sheriff deputy that I represented once for smuggling contraband into the jail. And of course, I made my argument to the judge, and I thought, this is going so well. Never been in trouble, law enforcement, judge, don't send him to prison. You know, his life's in danger, all that good stuff. And the judge, a former prosecutor and then judge, a very good judge that I had so much respect for, looked at my client and said, you had a badge and you spit on it. And I don't think I'd ever seen that judge that angry before. And he gave him the maximum penalty to prison. And I get it. I was representing my client, but I can understand why the judge was like, no, we're going to send a message here. And I know in some jurisdictions where they do have prisons, if somebody gets charged with contraband, let alone an officer, correctional officer that does it, it's just plain go to prison. So if you go into that work, you know it's going to be ugly, it's going to be dangerous, it's going to be low pay, but you're doing it because that's what you want to do. Don't screw it up, because if you do, guess what? You're going to get hammered. Next, an Indiana man allegedly was enticed by police into believing an undercover officer was a 13-year-old girl, and the man reportedly requested all manners of sexual acts and describing himself built like SpongeBob. Now, James A. Raber, he's 63. Take a look at this guy. All right. 63 years old. We'll give him the presumption of innocence. He's entitled to that. Okay. But Mr. Raber, let me explain something to you. You are 63 years old. Even if this was a child, this child could be your granddaughter. All right. I assure you, no 13 or 15-year-old has posters of 63-year-old men on their walls. You are not some 13 or 15-year-old's dream. And the fact that you think so is probably the reason why you're trying to hook up with a 13 or 15-year-old child. It's just weird, it's creepy, and it's gross. Okay? That's just weird. So anyway, James Raber, the 63-year-old guy, has been charged with attempted child molestation and child solicitation. Apparently, there was a lot of communication between the Randolph County Sheriff's Department deputy and Mr. Raber that began back on May 8th after a deputy created a fake profile on Facebook Messenger, according to the affidavit for probable cause. Guess how old I turned on my birthday? ? The fake account said that night, to which Raber responded, let me guess, 15? Nope, the police officer responded, 13. In the subsequent days, Mr. Raber sent an abundance of sexually explicit messages and inquired about how the girl gives the name Steph could hide out with him in a safe country. This is all according to the arrest affidavit, ladies and gentlemen. Anyway, Mr. Raber allegedly believed Steph was staying with another man, constantly asking if she was having sex with someone else and saying that he was jealous. He allegedly asked the fake profile to send a photo of herself and even offered to pick her up and take her to a bus down to Florida, where the fake profile stated that they wanted to go but not before she performed various sex acts on him. Now, according to the arrest affidavit, when the arrangement came together and they met, Raber again asked my sexy girl if she was having sex with the person Raber believed was the other man, and indicated he was pleased that she did not. Now, I'm a very big, tall guy, he said, 6'4", 295. I'm built like SpongeBob, adding a vulgar sexual promise. So if you've ever had a fantasy about effing SpongeBob, that's me, Mr. Raber said. Sure, every girl's dream. Anyway, guess what? On May 29th, when the detective posing as the girl suggested a little difficulty in being able to leave and arrive at their agreed-upon meeting spot, a village pantry in farmland, Indiana, Raber is said to have replied, WTF, that really screws me driving to there today. At that point, he messaged her to not walk to the bar where he was because they have cameras in the parking lot. Once the fake profile person said they were leaving to meet, Raber reportedly left the bar and went to the village pantry where Farmland Police Department officers and Randolph County Sheriff deputies were waiting for him. What a surprise. They claimed he was without conflict. The detective who signed the affidavit said they confirmed that Raber was the suspect when during their interview, Raber confirmed that it was his account that he was having the conversation with Steph. Raber's vehicle also reportedly matched the one that he described in his fake profile. Raber had an initial hearing on the charges on Wednesday, and he reportedly has an extensive criminal history, including convictions for DUI and several traffic violations, but he hit the big time now. So anyway, it's unclear whether law enforcement suspected Raber of criminal acts or desires before the messages began, and that's why they targeted him, or if they just happen to be targeting anyone. Needless to say, ladies and gentlemen, if you're a 63-year-old man and a 13 or 15-year-old girl is agreeing to meet with you, you can just conclude that it is a cop. Mr. Raber should be our dumb criminal of the day. I got a better idea. How about you date age-appropriate women? But if you're, 60 and you want to date someone 40 years younger, I guess you could at least make sure they're 18. Get a birth certificate, 2 forms of ID. Still a little weird and creepy, Mr. Raber. Good luck. Next on the docket, this day in legal history. On June 6th, 1788, Virginia's convention was debating ratification of the United States Constitution, which obviously established the federal judiciary and criminal laws, including treason. Virginia's ratification later that month solidified the U.S. legal framework. And on June 6, 1934, the U.S. Department of Justice designated notorious bank robber John Dillinger as public enemy number 1, making a pivotal moment in federal law enforcement history. On June 6, 1963, President John F. Kennedy delivered a televised address urging the nation to guarantee equal treatment for all Americans, laying the groundwork for the Civil Rights Acts of 1964. And on June 6, 2012, a federal judge ruled that the Defense of Marriage Act was unconstitutional, advancing the cause of marriage equality in the United States. And since I thought the cross-examination by Mr. Brennan was so good today, let me give you a cross-examination quote. All right? The purpose of cross-examination is not to create doubt, but to elicit truth. It is a tool to test the veracity of testimony, not merely to undermine it. Now, obviously, this quote underscores the discipline and the truth-seeking nature of cross-examination, emphasizing its role as a precise instrument in the pursuit of justice rather than a means of hiding the ball. I've said this before. I say this in voir dire, right? Each side has their purpose. They're advocates. And I said, ladies and gentlemen, if this was about the prosecution just presenting the truth, guess what? I would never have to get up and ask a single question. It would all have been answered. That was it. But as the United States Supreme Court has defined cross-examination under the Confrontation Clause of the United States Constitution, the greatest truth-seeking tool ever invented. And you can always tell the direct witness is trying to get by based upon the length of the cross-examination. If the cross-examination is longer than the defense, it usually means prosecution didn't do a great job getting their word out. Just something to think about. Next on the docket, our dumb criminal of the day. In a tale that proves some folks take gratuity way too seriously, a DoorDash driver in Vancouver, Washington, turned a missed tip into a high-stakes showdown. Robert Dellenhalt was so miffed about not getting a cash tip on a $100 delivery that he decided to make a house call, packing heat and bringing a bad attitude. This all took place last week while Dellenhart rolled up on the home of 19-year-old Kiana Korenkov, allegedly to demand a tip like a mobster collecting a debt. Now, according to the police, he was loud and mouthy, which is rarely the vibe you want from your delivery guy, right? Anyway, Korenkov's father, Anthony Valino, wasn't having it, and he told Dellenhart to hit the road. But instead of leaving, Dellenhart escalated things to an action movie level, reportedly reaching for a holster and a Ruger firearm. Valino, smelling liquor on Dellenhart's breath and sensing this wasn't just about a few bucks, grabbed the gun and shoved the driver on the driveway in a move straight out of backyard wrestling match. Home security footage captured the little tussle, showing the men grappling over the firearm before Valino disarmed Dellenhart and sent him sprawling. Dellenhart, perhaps realizing he miscalculated, peeled out of his Kia Soul and called police dispatch to spin his side of the story. The house cheated me out of a tip, so I returned and he was pushed, he claimed, as if he justified his armed encounter. Anyway, cops weren't buying it, especially since Dellenhart reeked of booze and later tested more than twice the legal limit. It should be noted that I shouldn't have come back, Mr. Dellenhart noted. He admitted to officers a rare moment of clarity from someone who thought a gun was the answer to a dispute over a tip. The security footage didn't do Dellenhart any favors, showing Valino holding the gun after the scuffle, charged with assault, harassment, and driving under the influence. Dellenhart's DoorDash career has been officially ended, and he's been given his walking papers. So if you're chasing tips, ladies and gentlemen, don't chase them when with a loaded gun, and leave the drama to the movies, and the 5-star ratings will sort themselves out. Good on you, Mr. Dellenhart. You need to go and deal with Mr. Indiana man with 13-year-old girls, too. Dumb criminals of the day. All right, everybody, that's all we have for today. Hope you enjoyed the show. Have a wonderful weekend. We'll see you Monday, and remember, the Constitution matters.